Good afternoon. I'm David Levy, Dean of the Duke Law School. Welcome to the annual Herbert L. Bernstein Memorial Lecture. This lecture celebrates the life's work of Professor Bernstein, who was a wonderful teacher, colleague, and scholar here at Duke Law School for 17 years before he passed away in 2001. Born in Hamburg, Germany, Professor Bernstein had a harrowing boyhood during World War II. He was educated at the University of Hamburg and eventually came to the United States in 1962 to study at the University of Michigan. He then taught at the universities of Hamburg, Berkeley, and Southampton before coming to Duke in 1984. His fields of scholarship included comparative and private international law. Professor Bernstein was a much beloved person here at Duke Law School. I did not have the pleasure of knowing him personally, and that is my loss. It is quite clear that he had a profound effect on all who were fortunate enough to know him. It is a particular pleasure to have Mrs. Bernstein here today with us. Welcome. This speaker series is sustained by the German Alumni Fund and by the Biddle Trust, as well as by many contributions from Professor Bernstein's Legion of Friends and alumni, the alumni who admired him so much. We are honored here today to welcome Professor John Bell from the University of Cambridge to deliver the Bernstein Lecture. I commented earlier this morning on Professor Bell's fine tie, which is, to my eye, a Duke tie. He corrected me immediately and said that, in fact, it was a Pembroke College tie. I think in the field of European scholarship, this is what we would call convergence. Professor Donald Horowitz will be introducing Professor Bell. Professor Horowitz is the James B. Duke Professor of Law and Political Science. He's a very distinguished academic scholar and teacher. He holds undergraduate and law degrees from Syracuse University. He holds 2 masters and a doctorate from Harvard University. He's the author of 6 books. He has visited at faculties, universities across the world. He runs our very successful Hong Kong Summer Institute. He is a member of the American Academy of Arts and Sciences, and he recently completed a 3-year term as president of the American Society for Political and Legal Philosophy. He was also a very good friend of Herbert Bernstein. Professor Horowitz.
Thank you very much, Dean Levy. Some years back, a professor at the University of Chicago Law School was the Curry lecturer here. And as he was, and I think still is, a friend of mine, I was asked to introduce him. When I finished and he took the podium, the speaker said he'd been expecting some friendly but stinging barbs and was relieved that he had survived the introduction. There's no danger that our speaker today will fail to survive the introduction. In the first place, I have no barbs to launch against him. And in the second place, what I have to say about him is exceedingly straightforward. It's this. If you want to know anything significant about French law, especially but not only French constitutional and administrative law, and these are big subjects in France, sooner or later, and probably sooner, you will become acquainted with Professor John Bell. That is because he is the most prolific and penetrating scholar of the subject, the author of books such as French constitutional law, the co-author of French administrative law, and of Principles of French Law. And he's been branching out. In 2006, he published an extremely ambitious country-by-country comparative survey called Judiciaries Within Europe. And if you think that's an easy job, have a look at the book. And he's just finished a history of European tort law, so he's not, as they say in Cambridge, merely a public lawyer. Professor Bell has been teaching at Cambridge for nearly 10 years, and we've been trying to get him here for almost that long. In fact, for a shade longer. And before that, he taught at Leeds, Oxford, and the universities of Paris I and II. He's going to speak today on the relevance of foreign examples to legal development. For us who were friends of Herbert Bernstein, the Bernstein Lecture is a very special event, and it is a privilege to welcome John Bell to deliver it.
Thank you very much for the introduction, and indeed for the very warm welcome that I've received here at Duke. Before I came here, I thought the Cameron crazies were simply the British Conservative Party front bench, but I have discovered a totally different meaning for that. Professor Bradley was very kind in introducing me to the mysteries of basketball. So I'm mainly going to present some issues arising out of a project that we started on the history of the development of tort law within Europe, which has those two websites, which you'll be able to pick up when this goes on the webcast. It's a project where there are 6 volumes due out in April, and then we've got another 3 to finish. So this is really part of the books that are yet to come, rather than the books that will be published. What do I want to do? What I want to look at is the idea of the relevance of various foreign laws. And there are sort of 3 areas that, for example, Jeremy Waldron has picked up in his Storrs lectures at Yale in 2007. One might say that there are certain common tasks of the law. There's the application of common texts. And then a third area where foreign law gets used is encountering common problems. And it's that third area which is the least straightforward that I want to concentrate on. What's been said by colleagues, such as Basil Marcasinis and Jeremy Waldron, is that there are some questions that you need to think about when you're using foreign law. You need to look at why you're using it, and you need to think about what argumentative force it actually has. Marcasinis and Waldron have both written on this area, and discussing very much the United States and in those debates. Whereas Marcasinis essentially argues that for a pragmatic approach, you use foreign materials because they're useful. Jeremy Waldron, in his Storrs lecture and in other papers, has tried to provide principled reasons why foreign examples should be used to question the way our law works. What I want to do is very briefly go through the common tasks of law and then concentrate on the other 2. Very briefly, governance through law is what we expect the law to do. And that's a common task. But there are different levels in that. The first of those levels is establishing social order. And Hans Kelsen came over to the States and worked particularly in California. He argues that collective security is the thing that law provides. It provides courts with compulsory jurisdiction and central executive organs whose coercive means that they're so effective that resistance ordinarily is hopeless. In other words, concentrate on political power and physical power over individuals and don't allow individuals to use private force. The sort of thing he has in mind, to make a slightly contemporary example from Roman law, would be, imagine you've got a student loan with a private company and you're defaulting, you're not paying. So the student loan company comes and kidnaps you and then takes small parts of your body and posts them to your family, encouraging them to pay up, and then trying to encourage them to pay up, or alternatively, sells you as a slave to the dean of another law school. Now, that's seriously where you start with the sort of council. The state gains monopoly to prevent that sort of thing happening, unless there's changes in the American law that I don't know about. But that's only really a starting point. What we normally associate with the law is the idea of the rule of law. And I'll leave with your dean or Professor Horowitz the recent book by Tom Bingham, who was the leading judge in the United Kingdom on the rule of law, which he's just published. But that's a very sort of British way of looking at the rule of law, and I'll cite it a few times. But the rule of law can mean a number of different things, and within Europe there are different ideas. One would start with the sort of German approach, which is that the law authorizes state action. State can't do anything unless the law allows it. The French always have inherent powers of the state, and therefore the law is there much more as a restraint on the powers of the state, and obviously gives extra powers, but the state always has a certain number of inherent powers. Driving licenses were something that came from the inherent powers of the state. And a more common law approach is to focus on redress, either through the tort system or through judicial review. But it's all about controlling the executive, the rule of law in that particular way. Now, Bingham, in his book, argues in favor of what he calls a thick view of the rule of law, where what the rule of law is about is not only controlling the executive, not only providing social order, but more importantly, involves protecting fundamental rights. And I won't go into this in any detail, but the point of fundamental rights, particularly in the German tradition, which is expanding within Europe, is not only to control the legislature, but also to control private individuals and the exercise of power. Everyone is subjected to that form of the rule of law. And then finally, particularly popular in say, France and Germany, is the concept of what they would call the social state under law, sozialer Rechtsstaat, where what you're interested in is law through solidarity, through various mechanisms, providing the conditions, the basic conditions for human flourishing. That's the job of law. Now you can see, in other words, there are different meanings to the different common tasks that could be given to law, and they're not always agreed. So one basic point when you're trying to do comparison is to find systems that are agreeing with what the fundamental task of law is. But that's very much high-level common ground. What I want to focus on is private law. And to focus on that, I'm going to give you a couple of sort of background things that particularly we Europeans tend to take for granted. Well, the first thing is that legal continuity is maintained by texts and principles, not by nations. Why would I say that? Well, an example. Town of Tournai. Tournai is on the western border of Belgium, close to France. And if you go into the museum in Tournai and look in the cabinet there, you'll see coins and medals. And it tells you about how Henry VIII, King of England, when England owned Tournai, built a tower, and then proceeds to put coins together of more recent vintage, where, for example, for 1787 you have an Austrian coin because it was part of the Austrian Netherlands. By 1795 it was a French republic, and in the course of that it acquired the French Civil Code. By 1814 it was part of the Kingdom of the Netherlands. In 1830 it became independent. In 1914 to 1918 it was part of Germany. And then in 1940 to 1944, also part of Germany. The point is, throughout more or less the whole of that period, it operated its own law, operating the French Civil Code through its own courts. It's about continuity through change in administration. Whatever country it is, it's the same law. Second feature that we take for granted is this is taken from a German commentary published last year on the tort provisions, one of the tort provisions in the German Civil Code, paragraph 823. And they don't put, these are the typical way the Germans cite, no names of parties, no dates. I won't go into what those letters stand for, but I'm happy to explain to anybody afterwards. But what that is just one footnote. It's got a series, it's got all these references in. But what it doesn't tell you is the dates and the regime under which those decisions were cited. So what you see is a multiplicity of different regimes. The interpretation of the code is just a text that gets interpreted, and the regimes don't seem to matter. You just take it for granted that the text is interpreted today, in its meaning today, and the cross-references are to previous decisions that illustrate the way it should be interpreted. There's no real sense of the judges today having a great deal of attention to the intentions of the legislature. They are certainly not interested in either interpreting the intentions of the Kaiser Wilhelm or Adolf Hitler. They are interested in what the text means today. So those are the sort of two background conditions for how Europeans tend to approach the interpretation of private law. And that leads to a certain kind of view of private law, where what we say that is that our legal systems are not really closed, because the boundaries between states are pretty accidental. Tournai, sort of, today it's France, next week, you never know. And anyway, the borders are very close. And the legal systems are built around texts that have been handed on from one period to another. And quite often the law schools were set up before the texts, and therefore they've been interpreting the law from various different countries. You take, for example, the French Civil Code was in operation in southern Germany, or in Italy, or in Spain, or in the Netherlands, because that was imposed by military rule by Napoleon. And with the result that the leading textbook through much of the middle of the 19th century was in German, because it was produced in southern German, and the French used to read the German commentaries on the French Civil Code. That's how that's how ideas moved, and some of the great ideas on interpreting the French Civil Code have actually come from the Germans. So, and the same applies to the common law in slightly different ways. Because the common law is also not confined to national boundaries. If you look at the citations in Australian, English, even American textbooks on common law, they kind of just cite common law decisions from a variety of different countries. The common law is essentially a family of systems, and a lot of development depends on reading foreign materials from other common law jurisdictions. But not only other common law jurisdictions. Particularly in the early part of the 19th century, the French Civil Code was cited very regularly in English courts. And to take one example, the leading case on damages in contract, Hadley and Baxendale, is explicitly based on Article 1148 of the French Civil Code. So what you get is a fairly quite wide reading of different materials as part of private law development. Now, what I want to do is to focus on a particular example. And there's always a problem with examples. comparative lawyers really can't decide what the purpose of their examples is. Is it to provide you with an example to follow? Or is it to give you a warning of what not to do? And to some extent, the answer is both. So I'm going to take one particular area of law, which comes in one of the volumes in the next series that will be published in April. The area of product liability, with which you'll be very familiar. And the point of it is to think about this as a new issue. So you need to go back. You're too young to worry about that. But as it were, think yourself back to a much older period. What you have in product liability is a new focus, is a new kind of ways of dealing with distribution. You've got production and industrialized products. You've got a different role for the manufacturer. So the manufacturer of the Ford Model T is responsible for producing very cheap goods. Cars become affordable. And it's also responsible for marketing. That's a big change. With the marketing, it becomes the manufacturer rather than the retailer responsible. So therefore, what's the job of the grocery store? Is it as the person on whom you rely for expertise, advice, or is it simply the distributor? Well, in the United States, very early, you developed supermarkets and very much became a sort of distributor of products rather than the person on whom you relied. It took a lot longer in Europe, and that really only developed after the Second World War, particularly after about 1955. But what that does mean is that the consumer is different. The consumer's position is different. First, the consumer starts exercising lots of choice. But secondly, the consumer has limited understanding of the product, often can't actually examine the product. It's all packaged. They take it. You go to a supermarket, typically it's all packaged. You don't know what's inside. So the question comes about what the relationship in law is going to be between the manufacturer and the consumer. And that poses problems. Now, the importance of the United States in that is that the United States was the place where that economic change happened first. So it was in the 1920s and 1930s, you got supermarkets, you got the various distribution chains that didn't happen in Europe as much. For example, whereas 30% of stores in the US in the end of the 1930s were supermarkets, that was only 7% in England and about 1.5% in Germany. So you've got very different economic developments. So that what happens is you get different pace of development. And what I want to do is to take two different countries and have a look at those developments. I'm going to do it through two individuals. First, Gino Gorla in Italy, a professor in Pisa, very important person. He starts, as one would expect in Italy, looking at France. France, the French Civil Code, was the code which was used quite frequently in the original Piedmontese code, and there was a discussion in the late 1920s about having a joint Franco-Italian civil code. The whole point is that the French developed in advance solutions dealing with motor cars. Most of the problems at this time of products were about motor cars. So the French developed in the 1920s various solutions, and he was picking up on those and suggesting them to the Italians. And that's in his book on sales, that's how he deals with it. After the war, he gets the opportunity to go to the United States. And in 1949 to 50, he's here in the States just as Trainer's early decisions on products were being developed, the Escola case. And that becomes interesting for him both the case method of teaching and the way product liability is developing. So in his next set of articles and books between 1955 and 1958, he's drawing not only on France, but he's also drawing on the American experience. And he's increasingly moving to strict liability. The strict liability can be provided through the French contract system, but the problem with the French contract system is it relied on a lot of fictions. I won't go into the detail, but basically you'll take it from me that it relied on a number of fictions. The French play fast and loose with their civil code. Never take civil codes too seriously. And what they were doing was creating a complete load of fictions that enabled the consumer to sue the manufacturer in sales law. That was going to be quite difficult for the Italians, and therefore the idea of strict liability in tort was another way in which Gorla was trying to suggest they could move. And all that came to a head in a decision in 1964. And if I can focus moving your cursor, put the focus on. Right, biscuits. So the Saiwa case is about biscuits that poisoned various people. When the case came to the court, the Corte di Cassazione, what you've got is knowledge through the various lawyers and through the writings, particularly of people like Gorla, but also some of his students. You've got clear knowledge of the American solution and the French solutions. And the court, it's very clear from the notes on the case, took cognizance of the solutions in French law and rejected them because they were too fictional, which were the ones that Gorla really preferred. But they picked up his American ideas, but weren't prepared to go quite as far as he and established strict liability. What they did was to introduce a presumption of fault. And that, you can see in the discussions in the case, means that you get to something similar to strict liability, but retain doctrinal purity to a limited extent. You create a presumption of fault that's actually difficult to rebut. Okay, second writer also connected is Val Lawrence in Germany. Now, Val Lawrence had managed to get some education in England, mainly because he'd initially been a prisoner of war in Italy under British rule. And he published a seminal article in 1961. Now, notice the date is before the restatement second, article 402A, which is 64-65. He's drawing on Prosser's work and Trainer's case law. And what you've got is they're looking at the way in which strict liability could be provided in the German civil code. And that comes to a head in a decision in 1968. Now, the interesting thing is that like Herbert Bernstein at Duke, there are a number of other German scholars who'd come over to the United States, and one was Rudolf Schlesinger at Cornell, who had both of them working on his contracts project in the early 1960s. So the point of the German influence here is that it begins to explain what's going on. And one of the contributors to our volume, Wagner, argues that with little exaggeration, one might say that product liability was imported from the US, both with regard to legal problem and legal solution into German law. The question as to why American law featured so prominently here is difficult to answer. One factor might well have been the immigration of eminent German lawyers, mostly of Jewish faith, to the US, which made it easier for scholars of German tongue to access the learning of American law. Throughout the 1960s, a relatively high number of German-born professors continued to teach at leading American law schools, and they were happy to introduce scholars from post-war Germany to American legal thought. So in other words, what you've got is the movement of individuals across, therefore with the movement of ideas, and Hans Kelsen, to go back earlier, was also one of those. So what you've got in the Falpes decision, which is a decision about a vet injecting chickens of a farmer with inoculation against Newcastle disease, which turned out to be faulty and led to the chickens having to be slaughtered. The question for the Germans was whether they would follow Lawrence's ideas, which were essentially picked up from Prosser and the restatement of having strict liability, or whether they would not. And there's a long discussion of Lawrence's views. And the court eventually comes to the idea, rather like the Italian Supreme Court, the Corte di Cassazione, to say, no, we can't quite go that far. We'll have a presumption of fault, which is more or less irrebuttable. So what you've got in both cases is an important way in which American law is seeping into both Italian and German law. And Lawrence is the key individual because he then goes on to draft the various the eventual directive, which now occupies the law of the entire European Union. So it's quite clear from these sort of examples that in the courtroom, foreign law is being used quite a lot. You've equally got that in the use by the legislator. As I say, Lawrence was involved in the directive on product liability and in the earlier convention of the Council of Europe draft on the European Convention. I won't explain the difference between the Council of Europe and the European Union, but I understand the problems your president has in understanding what Europe is. But it's not merely being used by the legislature to pick up. It's also being used by trade associations and by consumer associations. They're also behind some of the litigation, behind some of the, in particular in Europe, behind some of the lobbying for particular forms of legislation. And so what you end up with is modeled on American consumer associations. You have French and then other European consumers associations with their magazines. And perhaps the French would always say, probably the legacy of the Americans. You may notice there's a pun in there for those of you who don't read French. Descartes wrote, I think, therefore I am. Je pense, donc je suis. What you have here is, I spend, therefore I am. So what we're getting is that these consumer associations are pushing both litigation and are pushing legislation. Admittedly, the legislator is also driven by crisis. And perhaps the timing of legislation is very strongly structured around particular crises. So the Germans were particularly had particular problems with product liability as a result of the thalidomide scandal in the early 1960s, which the United States didn't have, nor did France. But there's also a problem of Planta in Belgium, or later in Spain, the colza oil case. Now, if we look at this, I mean, the first thing that I was picking out is that there's very much an important role for individuals, the role of individuals moving around, picking up ideas, moving on, playing leading roles as the interpreters. And that's an important part. You've also got legal development in both Italy and in Germany is not so much about actually borrowing a rule and plonking it into German or Italian law. The solutions adopted by the Supreme Courts in both cases was different from the American or different from the French examples that they were working with. They were trying to navigate between, if you like, the paradigm of progress, which America represented, and the paradigm of tradition, which was represented by their doctrinal system. And that negotiation was important. Now, did that mean that Gorla and Lawrence were not influential? Far from it. Although their particular favoured solutions were not adopted, first the court took seriously their ideas. They weren't some foreign extraneous idea which could be dismissed. Secondly, what happened was that, if you like, Gorla and Lawrence used the American example to change the paradigm. The problem was no longer a problem of sales with it or delict. It became a product of product liability using the sociological explanations they got from the Americans to see this is a different kind of problem and therefore needed different types of solution, a distinct problem with its own particular issues. And they were able to motivate and encourage, say, the German Lawyers Association, the Juristentag, to meet and discuss the issues just before the Foul-Pest decision. So you've got a change of paradigm that's going on. The second aspect is well pointed out by Guido Alpa, a leading Italian lawyer, who points out that in the 19th century, the Italians were translating everything and anything, and indeed they do today. What he was interested in is what they translated. And they mainly in law translated French and then German, but very large number of common law, about 160 books in the 19th century of common law materials. And he asked, well, why was common law not very influential in private law, although it was quite influential in public law? And he says, well, if you look at the books, the way people were writing about the common law was very critical. So the British, or Americans, mainly British people, writing about the common law was, it's overly complicated, it's out of date, it's got arcane structures, a codified system would be much better. Well, if you read that, why would you bother to look at the common law? You know, if the locals don't think it's useful, why would anybody else think it's useful? And I think Alpa's got a basic point, because what you get in the products liability is an enthusiastic common law saying this is the way forward, Prosser and his ways forward and the debates around the restatement. And so they're getting an idea that this is the modern way forward. Not merely is there a problem that's modern that the Americans are facing and have got experience with, but also their solutions are modern. And it's the kind of paradigm of progress which fits the zeitgeist of Germany and Italy and Europe after the war. You know, you've had all the dark days of the war, all the rationing and so on. You're then moving into a new era, the 1955 to 65, the German miracle. And that is the moment when, you know, these modern solutions and modern progress, they're looking outside their traditional frameworks. So it kind of fits. And so it's economic and legal progress being seen together. So it's not simply a question of how it's presented, it's also a matter of what the climate of the receiving community is. And it's those dynamics that need looking at when we're examining how different legal systems develop. Now, the final part of my presentation looks more particularly at the issue of, well, what is the argumentative weight that these different foreign examples have. And if we go back and think about legal reasoning, then what we need to remember is that there are different types of example of situation. I talked at the beginning that you might well have a common transnational legal text. Within Europe, we have a number of common transnational legal texts. The European, vast number of directives, which now occupy something like 50% of the legislation at national level, are from common texts, agreed positions in the European Union or in the European Convention on Human Rights. So those are, if you like, common texts, and therefore a German interpretation or a Danish or Latvian interpretation of those directives is obviously relevant because it's the same text. And there's a natural tendency to examine. The problem for us is language, and we don't always read Latvian, and therefore don't always know what they've decided. But there are various mechanisms to try and make it possible. So in other words, in that sort of situation, reading the decisions of other countries is relatively straightforward, and the argumentative force is quite strong because it's the same text. Therefore, in principle, we should be coming to the same solution. Slightly more broadly, we end up with common legal principles, and common legal principles might well be in common areas of tort, or for example, where we're operating with exactly the same principles, the same text often. If you have the French Civil Code, it's still in different forms in force in Luxembourg and Belgium. And therefore, naturally, they look across to each other, although the French are perhaps less, as Marcusinius points out, less willing to look at foreign examples than the Belgians. The interesting question is when we're not dealing with a common text or straightforwardly common principles. That's the area where we get debate about the extent to which foreign legal arguments are relevant. And what were those are mainly about when we have common problems like product liability. Now, Jeremy Waldron, in his Storrs lectures, tries to provide two arguments in favour of the giving principled weight to foreign legal arguments. Not simply pragmatic weight, which is essentially what Basil Marcusinius argues, which is that they're useful, so you use them. And if they're not useful, you don't use them. Waldron firstly argues from essentially equal treatment. And what he wants to say is, give a quotation from his writing. He says, people in one country are aware of the way individual rights are accorded to others, similarly situated in another country. They know that their government is supposed to be responding to the same principles, the same concerns, and the same circumstances as other governments. So they wonder about fairness and why different governments have not got their act together to ensure that in this world, like cases are treated alike. Give the example he uses is of a refugee camp where at one end, one agency is giving 2 meals a day and another agency at the other end of the camp is giving 1 meal a day. Is that altogether fair? I mean, what he's trying to argue is that we're trying to implement common principles, similar principles, and therefore the argument of equal treatment applies. The issue, I think, is the level of generality you're working at. You can work at a sort of high level of generality when, say, broadly outcomes should be the same. But whether, for example, in the case of injuries, you end up with compensation through the tort system or compensation through a social welfare system, there's not obviously an argument about equal treatment whether you have one or the other. In other words, you need to look more carefully at the context and the whole context, not the specific legal rule, or else you don't get the whole story. And so, I mean, Waldron's argument, I think, as a matter of principle, stands, but the implementation of that principle is the thing that's probably much more complicated. The second argument he puts is that we end up with an intellectual clearinghouse. I mean, these days, you are able to get information on almost anybody's legal system on the web. And therefore, what countries are trying to do, whether they're legislators or judges, is to look for the best solution. But what he's trying to suggest is that legal systems are not just trying to find the solution that best fits the genius or culture of their own society. I think Marcus Aurelius would agree with that. What they're trying to do is to look at the best application of principles in their own setting. And so he argues that there are sort of two aspects to this. The first aspect is methodology, how you go about making decisions. The example of another country is about how you go about making decisions, how you should approach. So you can use the American example as saying, well, how do you approach product liability? What do you understand the problem to be? And everybody follows that one. And then what kind of outcome do you want to achieve? And then what kind of means do you achieve? So you can get an order of questions from following another country's approach. There's a different question about what to decide, what you actually want to come with as a solution. That's very much about content. So in that sort of situation, you're very much needing to look at context. And I think what you end up with saying in those sorts of situations is that the context becomes all important. That you need to understand a bit more about the way in which the whole legal system operates and the kinds of solution that come. I think one of the key features in this area of legal reasoning is to think about how arguments work. I would say that arguments work essentially rather like threads on a cord. One thread won't hold up the whole weight underneath. But if you twist a lot of threads together, you begin to get something that's strong enough to hold up a weight. And to a great extent, legal argument works that way, rather than relying on a single argument. That very much what you're trying to do is bind in sufficient arguments to give weight or to give strength in order to pull up the solution that you want to achieve. Now, it's clear that when you've got a strong thread, when you've got a common text or so on, that is going to be quite easy to see how it manages to support the solution you want to reach. When it comes to dealing with common problems, then the weight is the strength of the thread is much weaker. And what you need to do is bind a number of those threads together. And what you find in looking at common problems is that the key will often be the change in paradigm. If you go back to the Italian and the German cases on product liability, what was key was changing the paradigm. Actually, the court tried to construct a solution within its own system. It's what I would call cross-fertilization. It's not transplanting, it's cross-fertilization. You are fertilizing, and it's an indigenous growth. And I think that's the sort of key way in which it works. You change the paradigm and then develop an indigenous growth, which is helped from the outside. And in terms of the weight, what happens in the Italian or the German courts was that solutions were given added force, particular examples are given added force by the fact that it fitted within the American paradigm already seen as something which represents progress. So that something which is progressive, not simply which is technically possible, which was the French solution, but very complicated, something that could manage also to be doctrinally coherent with the rest of the law. And so what you end up with is looking at not merely fit to the problem, does it actually deal with the problem, but also fit to existing legal principle. Does this particular solution fit to internal legal principle? And then finally, the aspect is the reputation. Reputation matters. If you look at a number of works of a number of my colleagues, they're pointing out ways in which, for example, the Hungarian Constitutional Court borrows from the Germans. Why? Because of the reputation of the system. And similarly, in Italy and in Germany, it was the reputation of the system, its prestige, its sense that it had long experience with the problem, that overrode the fact that it wasn't a proximate legal system. It wasn't the same legal family. But it had a greater authority than the French solicitor system, which was much more proximate. So if you like, what you're coming to is an idea of weight adding to internal weight, external weight adding to internal weight. There's got to be enough internal strength for the solution to carry. But looking outside is a way of transforming internal debate. And it's that sense of cross-fertilization which is the idea I want to leave you with. Thank you. And I think that leaves an opportunity for questions, which I was told I had to. So please, if you've got any questions or observations, observations are fine. Right, sorry, shall I take one back first? And then, yeah, okay, yeah.
You spoke on kind of the intellectual history and the role of the individual. How much, I understand that's your focus, how much do you think the economic transformations, especially with product liability after World War II, and the Marshall Plan and the changes in the European economy towards, in some ways, an American system, but in some ways not, how much do you think that affected product liability and legal transformation?
Well, I think you make a very good point, which is, I mean, essentially you've got to have the right conditions. And as you're rightly pointing to, the right conditions are not simply intellectual. They're also socio-economic, both in the modes of production that are going on and the general economy. I'd sort of focus in the slide with Ford and Coca-Cola about, as it were, the structures of production, the fact that, if you like, Gawler was writing very far in advance of the Italian economy being able to sustain it. And you get that happening in a number of systems. But sometimes intellectual can move earlier. So, for example, if you take Spain, which after Franco was, took a long time to develop into the late 1980s economically, it actually had a lot of the product rules and road rules introduced in the 60s and 70s because it was a sort of intellectual sign of progress. So that sometimes you will introduce rules for, as it were, intellectual symbolic reasons that you wouldn't necessarily have justified by the economic conditions under which you operate. So you're absolutely right. That's a sort of a mixed combination of things.
Right. So is this borrowing from different legal systems? Is this trending one way or another? Is it picking up? I guess I see two things. On the one hand, you have things like Westlaw, which make it really easy to see laws and codes from other countries and cases. On the other hand, most of the countries you talk about have pretty mature, developed legal systems.
Well, I deliberately didn't use straightforwardly the word borrowing because that gives the idea that you take the same thing and then put it in your legal system. And that does sometimes happen. You take the same text and put it in. And I think one thing we're learning in the European Union with the way of legislation we've got is that doing that causes a lot of problems. The one reason why this Products Liability Directive has basically failed across Europe is that you've tried to deal with one problem and transfer but one bit of the law. And what you're finding is the Germans and the French and the Italians are all going around the outside. Any good lawyer knows there are limitations, for example, on the types of damage you can recover under the Product Liability Directive. So what's a good lawyer do? Plead the case in a slightly different way, and lo and behold, you're round the back of it and using your existing law. So in a sense, that's why it needs to be if it's going to stick, as the German and the French and the Italian solutions have stuck throughout and been effective, it needs to integrate with other bits of the law. You can't quite pick off one bit, put it in and hope it works. It isn't like picking in a new program, plugging it in and expecting it to run a new computer. It doesn't really work like that. So, that's why I was trying to avoid the word borrowing. But the point you're making is the access to things gives you the opportunity to think about how they're soluted. But you need to understand how it's working in that system. And that usually takes a certain amount of time and talking with lawyers in those systems before you've really got the hang of what's going on and whether it really is that different from what you're doing.
George, did you want to ask a question?
Okay, yes, I had a couple of observations. I really enjoyed your talk, John. It's very informative. Let me suggest something you might want to put as a coda sometime. In a sense, there's been a convergence back towards the middle because, as you know, in the United States, the only truly strict liability now is really with manufacturing defects. With regard to design defects and failure to warn problems, at least for big companies, because the standard is you should have known about it or should have done a cost-benefit analysis and what have you. You're really back to sort of a negligence sort of theory, at least for a big producer. For a smaller producer, of course, who doesn't have the means to ferret these things out in the scientific literature, then it is starting to approach a little bit towards a strict liability. But as you point out in German law, by having this almost ironclad presumption, building on Trainer, the use of the res ipsa loquitur, you've got something approaching a rebuttable presumption of negligence. So that's one point which you might just want to
that's
a little
good.
bit later. The second point on the more theoretical level is one thing that hinders the coming together of legal systems is the procedural aspect of things, because in a common law system, particularly in the United States, in which findings of fact are really almost, compared to Europe at any rate, relative to the province of the lower courts or a jury, you're going to have much more variation of result than you would have in a civil law system. And insofar as that's kept, you're going to have some differences, as in some of the judgments of the European Court of Human Rights, where it's intruded into factual questions which normally would have been left to the British courts. And the British courts, in turn, gave, or at least took, well, as long as it's a reasonable conclusion by the trial court, that's it. But the European Court of Human Rights felt that some greater examination was necessary from the people on high. So, anyway, it's extremely interesting talk, and I'm very pleased to be able to give it.
Well, if I can just take the second point. The first point, yes, is absolutely right and shows that, as it were, the problem of importing snapshots. they change over time. But the second point is you also get that problem because superior courts in continental systems leave a lot to the lower courts because they can't deal with it. They're already dealing with huge numbers of cases. The French Cour de Cassation deals with about 22,000 cases a year as a Supreme Court. And so you've got a problem. And so what they do is that they leave to the lower court judges, and of course they almost never get appealed. Or even if they go to the Court of Appeal, it doesn't actually get decided much differently. So you actually end up with this sort of dynamic you can get lots of different solutions, particularly in countries like Italy, where you've got very senior judges who remain in post and get higher pay by staying put. So the dynamics are slightly more complicated because not only is the variability of juries, but there's actually variability of judges even in lower sorts of jurisdictions. But the dean is going to wind me up.
Thank you, Professor Bell.
Thank you.
Great. Really good.
I can leave you with the book.